rise. The Court of Appeals, Division 1 is now in session.
Good morning. Be seated. Now is the time set for oral argument in cause number 1, CACV 180028. Is it Orduno or Orduno?
Your Honor, it's ORDUNO.
Orduno, thank you. Orduno et al. Versus Phoenix. The second one I got right coming out of the gate there. For everybody's information, these proceedings are being both audio and video recorded. So barring any problems with the recording devices, you can critique yourself on YouTube in a couple of weeks. Counsel, each side will be entitled to 20 minutes, and we would ask that you request the time period. It is the standard amount we allow here. The timer located on the podium will let you know how much time you have left. And for the appellant, if you wish to reserve any portion of your 20 minutes for rebuttal, please let us know. We will make best efforts to avoid taking up all of your time. However, ultimately, the rebuttal time being saved is up to you. We've reviewed the briefs, conferenced the case, so we are well aware of the facts and issues attendant to this argument. And we tell you that so you can figure out how you want to structure your argument today, how much time you need to give to whatever you feel like you need to give it to. When you come to the podium, I would ask that each of you state your name and who you represent so we can keep that clear for the record. And with that, appellant, you can begin.
Excuse me. Mike Napier. I'm here for the plaintiffs. Below, we had a motion for summary judgment. It was granted by the court. We had no claims left standing, although only one portion of the motion for summary judgment was given attention in the minute entry, and that was the immunity issue, so I'd like to get right to that. I think the court erred in applying immunity in this case and granting immunity to the city of Phoenix. Essentially, that's a statutory or a codification of an earlier Supreme Court decision, Orion, and it's ARS 12-820.01, and that serves as the platform for the analysis of the immunity issue. Here, the courts, or rather, the courts have said over the years that any kind of fundamental broad-based policy decision that weighs risks and costs and that kind of thing, they're protected. However, the courts, in addressing the efforts to invoke immunity over the years, have said, let's take a look at this because, and key in on the word of exercise of administrative function that takes an affirmative act, and they key in on that and they say, well, that's either broad-based or it could be operational. It could be routine, it could be day-to-day, and that is not protected. And that is exactly the facts that we have in this case. This is a case where the facts distinguish it substantially from the Cole case versus City of Phoenix, a 2007 case. There are several reasons.
Counsel, substantially, right?
I say substantially,
okay, so
yes.
Let's list out the points.
All right, let's do it.
One by one. How is this case different from Cole's?
Okay. In Cole, the court, Supreme Court, examined the relationship between the parties, examined the process by which the City of Phoenix identified a number of dangerous intersections. And there were criteria that were plugged into a computer process by the name of SIGWAR. And they identified 20 dangerous intersections. Now, that was the case with both broad-based fundamental policy, and that was the computer, the decision to use the computer to identify the intersections. It was also a case where there was operational decisions because the engineers examined the top 20 intersections and made a decision which are the most feasible to improve.
We were discussing the computer this morning, actually. And I have to say, to me, it seems like the computer is an absolute red herring in Cole. The computer is a tool, and the analysis that created the immunity in Cole could have been done on a blackboard. as long as the blackboard was large enough. Isn't
Well,
that right?
If they had specific objective, hard numbers and factors that they're putting
it
into
seems
it.
to me that what created the immunity in coal, and tell me if you disagree, was the fact that the city had decided to allocate resources, a certain amount of resources to a certain type of project. And then it had to prioritize how those resources were going to be allocated, and once the resources were gone, there were no more projects.
I would agree with that.
Okay. And that seems to me to be the key message of coal, not that we are suddenly acting at the behest of our computer overlords or anything
All right,
like
but
that.
let's
You would-
differentiate.
What?
Let's differentiate between that and what we have here.
Well, that's what I'm trying to do, because I fear that when we talk about coal, we all get so wrapped up in the fact that there was a computer that we forget that what's really at issue is the question of resource allocation on the one hand, which is fundamental government policy,
Right.
versus discretionary engineering on the other hand, which is not.
Yes, Your Honor.
Okay, if we agree on that platform,
Right.
Go
and
ahead.
the problem in that case was after they had established a broad-based policy decision, they then subjected it to implementation and let the engineers look at it. Well, this intersection that brought injury to or death to Clay Cole was never examined by the engineers. There was no operational process that was employed in that case. It was all broad-based, and the decision was derived from that.
would I be wrong,
The
though?
engineers never looked at this intersection.
Well, I understand that, but sometimes immunity can be counterintuitive. You feel like you're through the looking glass. Sometimes the less done and the less discretion, the more immunity. So what I'm trying to get to is whether my understanding first is correct that there was a policy decision to deprioritize those bus stops that lacked sufficient real estate around them to move them.
I'd say not.
You would say not.
Well, there was a decision. There was no ranking. There was no list. There was no prioritization process.
There were no criteria at all?
There were some that were employed on a day-to-day basis operationally based upon the judgment of two individuals, including the superintendent of the transit department. They said the two of us went out. We took a survey. We looked at the bus stops. Part of that was to make a decision at that level. Not, there was an allocation of funds, never for safety, but always for ADA compliance, furniture, shade, amenities, that kind of thing. But in any event, even when they applied those funds to the bus stops, it was basically the people in the Department of Transportation, and they were making the decisions. He said, there's just the two of us doing that. We go out, we survey it, we inspect it, we decide if we're going to bring it into ADA compliance, not safety compliance, but ADA, and they decide if they're going to seek a right-of-way. They use maps. They could do a survey. They didn't. They could have asked for a right-of-way permission consent. They didn't. That was all operationally done in this case.
But if they decided never to upgrade any bus stop,
Right.
would we be here? I mean,
Yes.
The decision to do nothing.
Yes, we'd be here.
Really? As a matter of fun, I won't load the question. If the city had just decided, we're not doing bus stop upgrades for the foreseeable future, we're going to focus on street festivals,
Right.
wouldn't they be absolutely immune from that?
No, because the bus stop is unsafe. We say it was unsafe when it was installed, and we have testimony from Boyles to that effect. We say also that when you apply this statute, you can't do it by default. There has to be an affirmative decision, and there was never any kind of fundamental broad-based policy under your hypothetical to improve, make safe the bus stops. You still have an unsafe bus stop. And over the years, there's a chorus of alerts coming from every standard in the industry, including AASHTO, who puts this in a high crash zone location, saying this bus stop is unsafe, calling out to the city, do something about it. We'd be here, yes. And by the way, one other subjective criteria that the city applied when they decided to allocate resources on an operational basis was to evaluate ridership. Not numbers. We never got a number. It's just subjective. It was operational. It was day to day. That's how they applied
Well,
the
let's
decision.
talk about objective criteria. How many bus riders, people who have been waiting at this bus stop historically, have died in an accident?
None that I know of.
No. Okay. How about seriously injured?
If we're getting to whether it's unsafe,
Well, no, you were saying that
let me answer your question.
ridership.
Seriously injured my client, Your Honor. One.
No, but we're looking at, you're talking about criteria, and you said that, I forgot what the adjective was, but ridership, the number of people who boarded during the day, you described it as?
Ridership.
No, but as a criteria, irrelevant?
It was a criteria. It was applied operationally by the superintendent of the transit department and his assistant. It was one of the criteria, not objective, purely subjective, no hard numbers.
How is that subjective, the number of people who board a bus at that stop during a day?
The number is not. The ridership factor is. They never put a number to it. They never put a number to it. Oh, not too many people use this bus stop. We're not going to improve it. We're not going to make it ADA compliant, let alone safe. So I say it's not an objective. It's not a hard number, as the city would insist.
So would the quantification of the people riding that bus during the day weigh on the issue of whether it was a safe or an unsafe bus stop under the criteria for creating bus stops?
No, it goes to the issue of whether or not this is a broad-based policy, which it was in the first instance, but rather, was this operationally applied, this policy? As in Cole, when the engineers looked at the 20 intersections, here it was operationally applied, very subjectively all the way through. Why didn't they get a right-of-way, for
Didn't the
example?
city, well, that's what I was just going to touch on. Didn't the city look at whether there was a right-of-way at this bus stop?
Mr. Munoz did, as part of his job, after they made the allocation of funds. He said, oh, we don't have a right-of-way. We can't move it the 2 feet back that all the standards require. We can't get it out of the high crash zone. He didn't even bother to go to the owner and ask. That was his choice. That was his prerogative on the operational application.
But isn't it,
No, they never sought the right-of-way.
maybe I'm misunderstanding the record, and I want to be careful that I don't, but wasn't it part of the city's prioritization scheme that those bus stops with right-of-way available would rank higher than those without? If I'm wrong
No.
about that, I want to know.
No. Their scheme, the overriding policy, the broad-based policy, was simply this. Let's put some furniture in, let's get some shade, let's make repairs, and let's make it ADA compliant, and never did, at a high level, did they make a decision based upon right-of-way. That was all done administratively, operationally, by the Department of Transportation.
So you're saying that a concrete list of factors to assess the safety of the population of intersections and a decision identifying 10 doesn't convey absolute immunity, because apparently we have unsafe stops or intersections that aren't on that list, and so there's no immunity for them. Is that your argument?
No, it's not. There is immunity in that instance. That was a case where they allocated funds to make intersections safe. They also had operational decisions, but it didn't apply to the intersection that the young man was killed at. So I'm not saying that.
Does this city allocate funds to improve bus stops?
They do, but not to make them safe. They
Okay,
never had a policy
well,
for that.
Is there a sum of money budgeted to improve, let's say, bus stops?
Yes.
Okay. And is there an analysis, and that's I understand a terribly vague term, but to select among the worthy recipients the worthiest of improvements to get that money annually?
No, not at the administrative level, not at the government. Not
So
at
how
the-
do they decide that?
Mr. Munoz and his department on an operational basis, routine, day to day, with the factors that I earlier listed. That's how they decided it.
And are you suggesting
This is
that-
not coal. This is a tumbling tea, if anything. I would like to mention that case.
And the anything is a question I want to ask you about. You've talked about them going out to the stops, them going in and making the decisions, how they're changing them. You've addressed the fact that the city has a certain amount of money that's available. Is that money, how is that money distributed between ADA and safety?
Nothing to safety, everything to ADA.
Are the two unrelated? In
Once
other
it-
words, if this bus stop had been made ADA compliant, would it have been safe within the definitions of your expert?
Well, there's no database safety-driven analysis. But coincidentally, if you comply with ADA, you're going to be 8 feet off the curb.
That's what I'm
Ruby
asking.
would have been missed. Nevertheless, let's take that as the list. There was no ranking, by the way, but let's take it as the list. By direction or alphabetized, whatever the case may be, the only ranking list came out in April of 2015. But let's take that list. We still have the operational application of the money at the Department of Transportation with the criteria that I indicated. This is not coal. This is more like the flood control, where they allocated money for flood control, and then the engineers decided, okay, where are we going to put it on the Gila River, and what are we going to do? What's the configuration going to be? Operational. Actually, not as clearly operational as the decision-making in this case on how to spend the money. And that's why immunity doesn't apply. So I better save some time. Is that okay?
It's your time, as we said when we started.
Okay.
Thank you.
But I shared it with you. Thank you.
May it please the court, my name is Jeff Smith. I represent the city of Phoenix. It sounded to me from some of the questions that were posed to my opposing counsel that the court does have an understanding of the immunity issue involved in this case. Let me point out a couple things that were raised initially. If you look at the Cole case, I have it here, it's the Arizona Supreme Court case. One of the issues was, what's the significance of a computer? If you turn to paragraph A of, or paragraph 15 of that court, or that case, the court specifically says, as the Court of Appeals recognized, the city's decision to use a computer program in selecting intersections for prioritization, rather than placing signals at every ostensibly dangerous corner, regardless of cost, and here I put in quotes, or using some other method of analysis, which is what we did here, to determine which corners among many worthy candidates receive traffic signals, is precisely the sort of policy-making decisions protected by 12.8.2001.
So that other method, your colleague characterized it as one person just sort of making ad hoc day-to-day decisions as to where money will go today. Is that accurate?
No, it's not accurate. There is a list of criteria that was selected by the Transportation Department for the City of Phoenix for improvement of bus stops. That list includes whether or not the bus stop's ADA compliant. Our bus stop was installed in 1989 before the implementation of the ADA. The ADA requires a certain pad size, 4 by 8 feet. As council mentioned, if this pad was installed so it was ADA compliant, the negligence theories that the plaintiffs have in this case, meaning the bus stop back a certain distance from the curb and even a curb in place, would have rendered this bus stop safe according to the plaintiff's counsel's experts. So ADA compliance is one factor. Ridership is another. Do we have low ridership, high ridership? At this particular bus stop, we have 10 riders per day. At other bus stops around the city, we have hundreds. This is very low ridership. Also, the other factors that are included is their right-of-way. That is an objective issue. It's not subjective. does the city have the property that it can put the pad on? This bus stop is right on the property line of this street and next to homes that are now businesses that were constructed in the 60s and 70s. And so we don't have right-of-way. And so simply going, as council suggested, to the landowner and saying, hey, could we move our bus stop 2 feet back? Would it be all right if we let people stand on your property? Would it be all right if we exposed you to potential liability if something like that happened? How would you be agreeable to that? That's just simply not feasible. There would have to be some sort of eminent domain or something like that, which again is government funding that would have to be expended to obtain that.
I guess maybe the significance of the computer, at least atmospherically, is some sense that the computer will apply the rules given it without variation, without discretion. I certainly don't think that a computer is required, but it does seem to me that to fall within Cole, you need to demonstrate that the rules were preconceived and then applied with rigid consistency.
Well, and that's what Herb Munoz testified. He's the head of the transportation department that's involved in this part of the work for the city of Phoenix. And he said in 2011, all the bus stops, including this bus stop 288, was evaluated for improvement. And they used certain criteria. It was ADA compliant, or whether it was ADA compliant, whether there was an existing transit pad, ridership, sufficient right-of-way, all of the elements that the city needs to improve bus stops. And certain pads and certain bus stops had a lot of those elements, and so they were higher on the priority list. Our bus stop did not have any of those. And so in terms of expending funds for immediate improvement and expending funds for making this pad ADA compliant, it was ranked so low on the prioritization list that it just did not occur.
Was there a target number of bus stops to improve that was budgeted for?
I don't have the answer to that. There is not a target number of bus stops as of 2011.
I don't need to know what the number was. I'm just asking if there was a budget that contemplated we're going to do X number of bus stops.
There was.
Okay.
Council, is there a minimum that has to be reached before a bus stop will be maintained or created?
A minimum set of criteria?
A threshold. We're not going to put any bus stops in the high-speed lane. We can all agree that that's probably a good idea, right? We're not going to move it over into the center of the road where people have to cross traffic to get to it. Fair?
Agree. Yes.
Is there I'm assuming that that's probably something that we don't do. Is there a minimum criteria that maybe it doesn't reach ADA, but it is still acceptable because is there a minimum, or is it just your life's in your hands when you go to a bus stop?
Well, I don't think, well, and you have to look at the facts of this case. I don't think anybody's life is in their hands when they go to a bus stop. What we have in this situation is two brothers racing essentially, one in front of the other going 20 to 30 miles an hour over the speed limit on a 35 mile an hour roadway when a woman pulls out in front of them. The brother at the end of the track basically locks his brakes up to avoid his brother in front of him, swerves around him, then swerves around Diana Merriquin, the woman that pulled out of the private drive 300 feet below south of our bus stop, swerves around her, almost goes into opposing traffic, loses control of his vehicle, and spins over the curb, over the driveway, and unfortunately strikes Miss ORDUNO and injures her severely. He ends up backwards facing in a building pretty far away, several hundred feet away from where the bus stop is. That is not a situation where generally people are taking their lives into their hands when they're standing in front of a bus stop. This particular situation was two people essentially drag racing on the roadway, and somebody cuts them off and they lose control of their car. That is highly unpredictable. If you look at the statistics we cite in our brief, it's pedestrian versus vehicle accidents in the city of Phoenix make up 1.4% of all collisions in the city of Phoenix during the time frame we cited. And that doesn't mean pedestrians standing at bus stops, that just means pedestrians in general. And so I don't think anyone's taking their life in their hand by standing at a bus stop, especially one that has been standing since 1989. And as the court recognized, there have been no reported accidents that anybody knows about involving pedestrians standing at this particular bus stop ever.
Is there a minimum criteria that has to exist before a bus will turn its signal on and pull to the right?
There has to be a bus stop in place that's approved by the city of Phoenix, which occurred in 1989 when this was installed.
I think the question is maybe the bus stop will pull over as long as there's a bus stop, no matter how dilapidated or otherwise unsafe it might be.
Well, so I don't, so there's a bunch of variables to that question. I mean, if there's no one standing at the bus stop, will the bus stop at the bus stop? And I think the answer to that is no. I drive behind lots of buses in the city that don't stop at bus stops because there's no one there.
They all seem to stop in front of me.
Yeah.
Okay.
The question as to whether or not a bus stop is safe or unsafe, I think all bus stops are safe in the city of Phoenix. The issue in terms of safety in this case is if it is ADA compliant, does it become safe per the plaintiff's expert's opinion? And the answer is yes. There was an affirmative decision not to improve this bus stop based on criteria selected by the city of Phoenix, and it wasn't improved as of 2011. And I think we have immunity for that.
I think there may actually be one point on which you and your colleague agree, which is that there's no consideration of safety at all in the bus stop improvement program, right? That all you're really focused on is general modernization and ADA, but you're not looking for the latest and greatest bus stop safety standards.
Well, I disagree to some extent with that. The ADA itself provides guidelines that are used in all kinds of cases to set safety standards. And so if this is an ADA compliant bus, per those standards, it's deemed safe, which was admitted by my opposing counsel.
Right. There may be some crossover between safety and ADA, but there's nothing that the city thinks about above and beyond ADA compliance under its policy right now.
No, that's inaccurate, because we have bus stop handbook that was issued in 1993 and 2008 that talks about design and implementation of bus stops and ways to protect from traffic that's traveling near there. It depends on the size of the street. It depends on the location. It depends on the right of way. A lot of these cities and roads within the city of Phoenix were constructed years before any of the standards were adopted. So if we constructed the bus stop now, brand new, based on the current guidelines and the current standards, the 2011 ASTRO might be in play, meaning we have to have the bus stop itself a certain distance from the edge of the roadway. We would have to have the ADA transit pad. We would have to have certain design ergonomics that comply with the standards that are currently in play. And so, yes, there are safety standards. They're inherent in the guidelines that exist today.
Hey, but that strikes me as your engineering goal, not your criterion for deciding where to do the work. In other words, if you decide to improve a bus stop, sure, there may be safety standards that you're considering and aspiring to and all that good stuff. But when the city decides we're going to work on this bus stop or we're not going to work on this bus stop, my question is it taking safety independent of the ADA into account, or is it really saying we've got to make some bus stops ADA compliant, let's pick the ones we can do now?
No, I think safety is inherent in the installation of all bus stops and the maintenance of all bus stops. I mean, but to quantify what you're talking about in terms of safety is a little vague to me, simply because that hasn't really been delineated by my opposing counsel in terms of what is supposed to be the safety consideration.
For purposes of this question, I have no interest in what your opposing counsel argues. I'm only interested in what your client was thinking years before this accident took place.
So there were bus stop standards that were issued in 1981 that have been disclosed in this case and were part of our motion for summary judgment. The bus stop was installed according to those bus stop guidelines at that time. In terms of what safety considerations as a specific term were utilized for the decision on how those standards were developed and then subsequently the bus stop was installed, I don't have a specific answer for you.
I don't want to belabor this too much longer, but my question's a little different. When you're deciding which bus stops to improve at all, in any way, is there a set of criteria that examines safety independent of the ADA in making the decision whether to do work at the bus station? Not how to do it, not how it was done in the past, but in that decision, is there a set of criteria?
I'm not aware of a set of specific criteria. I think it would depend also on the specific set of circumstances involved. Is this a high crime area? Have people been attacked or something like that? Do we need more lighting at this particular bus stop because there's been a series of injuries or attacks, or vehicles coming off the roadway, or all number of things? That would be something that would be decided on an individual basis per bus stop, I believe.
Let me piggyback on that. So on page 28 of your brief, you say, quote, "There is no requirement that safety be considered when determining fundamental government policy, but that rather this is about allocation of resources." I don't see a citation for that. Do you have authority that says that?
I don't have authority either way.
Either way.
Meaning I don't have authority that says that affirms what I'm saying here, or that says I'm incorrect. But there's no authority that says safety consideration absolutely is something that has to be a criteria when a city is making, or a public entity is making, a decision on what criteria to use for improvements and maintenance of facilities. The statute.
So it's unsettled.
It's unsettled.
Right.
And the statute itself says it's discretionary.
Well, discretionary just means thoughtful, right? What goes into that decision, right? I mean, discretionary, you could say, well, I'm going to improve this bus stop because today is the 26th of February. Okay, that's discretionary. I mean, discretionary is only informed by what is considered. So you're saying there's nothing that defines what you have to consider. It just has to be considered.
No, what I'm saying is that there are standards like the ADA, like the bus stop handbooks, like the ASHTO, that are the standards that if we improve the bus stop, we have to comply with. And those standards have taken into account safety considerations for users of the bus stop, pedestrians and traffic. And so if we improve the bus stop, the safety of the improvement is inherent in terms of the work that has to be performed per those standards. But when we're determining what criteria to use for improvement of a bus stop, the criteria that was decided, which the City of Phoenix has immunity for, is things like ADA compliance, right-of-way, ridership, shade, things of that nature.
Council, when I think we've all seen a lot of road improvement in Phoenix over the last, say, 50 years. If we take Camelback and widen it from 4 lanes to 6, what is the standard for what the bus stops along that road are going to be crafted? What level are they going to be crafted to at that time?
Well, it depends.
You're starting from scratch now, right?
I'm starting from scratch.
You're widening those roads out so the old bus stops are gone.
First, it depends on
Where do you go with that?
First, it depends on the available funding. Then, once the funding is determined, the city spaces bus stops generally a quarter mile apart. And so I think the city would continue to space those bus stops at that distance. Then what the city would do is comply with the 1993 and 2008 bus stop guidelines that are in place that we've cited in our brief. The city would also comply with other relevant standards in terms of the ADA, pad size, waiting area for handicapped people, shade, lighting if necessary, and those are that's what the city would comply with in terms of constructing essentially brand new bus stops, because that's what would occur.
So if they're building brand new bus stops, they're going to build them to a standard that comports with?
The ADA, the 1993 bus stop handbook, the 2008 bus stop handbook, and the other guidelines like the ASHTO guideline. And so if we improve the bus stop, we would do the same thing.
Let me ask you a question. Let's say the City of Phoenix came up with a list, finite amount of resources. They have to identify where that money is going. But the committee was comprised of folks who are concerned with aesthetics. And so they have selected the 20 least attractive bus stops to spend that money on. Clearly, you would agree with me, a discretionary act, right?
Yes.
Okay. And they disregard safety. Does that qualify for immunity under Cole?
I think it does. I think that policy-making decisions regarding how, when, where to spend existing resources per 82101 and Cole are entitled to immunity. I think there's a difference in terms of an operational decision, which is what council has talked about quite a bit, and that is when you make the improvement or when you construct the facility, do you comply with the relevant standards? If you don't comply with the relevant standards, then you have made the wrong operational decision and you're negligent in terms of the implementation of the construction, the maintenance, use of the funds, and then there would be a claim. But in terms of making a decision about how, where, when we are going to allocate funds and the basis for that, that's a fundamental policy decision that's entitled to immunity.
And so if I add on a fact that 5 people were killed in the calendar year at a particular bus stop, but this aesthetics committee was particularly concerned about the style of another bus stop that was a block north, it's same answer.
I think that if there was specific policy decisions made about how, what, where to spend existing funds, you're entitled to immunity. The young man in Cole was struck and killed by an automobile and killed because that intersection was not improved. Now, it didn't involve aesthetics, but it did involve a decision to spend money on different intersections. And so the decision to spend money on different intersections was entitled to immunity, just like I think in your example, immunity would be provided to the city. So I don't have anything else unless you have questions.
Thank you, Council.
Thank you. This will be an important 4 minutes. First of all, it's apparent that a hard look at the record is appropriate. We start with, of course, that immunity is the rule, or rather the exception and not the rule. Sparingly applied, narrowly applied. The council said that I indicated that if it was ADA compliant, the bus stop would be safe. That's not so. It's still between 2 driveways. There's still no curb. It was unsafe when it was installed. We have a human factors expert that was injected a question of fact in that respect, saying...
Council, is there any discovery how many bus stops there are in the city of Phoenix that meet those 2 criteria? Are we talking about, if those are the criteria, hundreds of bus stops need to be immediately improved, or is it just a handful?
The evidence in the case is there's 1. That's the evidence. 1 that's 5.5 feet back, or 6. 1 is out of compliance with the city's own code and AASHTO. They don't have AASHTO in their office, by the way. But in any event, 1. It's on dirt. 26 years ago, they stuck a post in the ground, and they left it there, despite that chorus of cries that this is, now you know this is unsafe. It's not up to standards. It's an issue of fact. So it's foreseeability and so on. It was between 2 driveways. It's not supposed to be next to 1. It was in what AASHTO predicted, and actually what happened, between 2 driveways in a high crash zone, as they called it. The city knew that too. They made that decision. They didn't say, here's the number of bus stops you're going to fix. They never said that. They never gave a number. They said, here's some money. And Munoz and his staff made the decisions. Judgmental, day-to-day, exercising discretion. Let's talk about right-of-way. We don't really know that they didn't have right-of-way. They went from the maps, which were imprecise. That staff in the Department of Transportation made the decision in their discretion not to do a survey. That would have told us.
Does it matter if they were wrong? I mean, as long as they believed that the criteria were met and they were applying them consistently, doesn't immunity then shield them from errors?
Yes, but it's discretionary. It's not objective criteria, just like the ridership. This 10 riders per day, I never heard that before. There never was a number. It was low or high. It was all discretionary with the staff and the transportation department. That is not protected by immunity. That is operational. All this was done that way. And this bus stop didn't change over the years. The issue about how many accidents, how many people injured or killed, whether the bus stop's safe doesn't turn on zero statistics. It turns on expert opinion, it turns on standards, and even Boyle said, and this is in the record, he said this bus stop was unsafe when it was constructed, if you want to call putting a post in the ground, constructing. He said it was unsafe then. He's an engineer for the city of Phoenix back then in the period of time, and he knew what the standards were. Between two driveways, it was unsafe. And also this idea about what if they did nothing? Well, if they did nothing, then you're not entitled to immunity. You have to make an affirmative decision to set that policy. That's Galati versus city of Lake Havasu. And you don't get immunity by default.
So, Counsel, you're saying we can't look into, I mean, I assume that experts form their opinions based upon numbers.
Yes. Well, numbers. You mean number of what?
No, your point you just made was the number of accidents is not important or material. It's
Yes.
what experts think.
It's what experts opine, yes.
Right. But
in
are
part.
we allowed to consider what an expert considered?
Certainly we are.
And that's maybe the history of accidents at a particular location?
But that didn't factor into a determination whether it's safe or unsafe. That makes no criteria. That's not a factor in any determination or standard. It's unsafe. Doesn't mean somebody has to get killed.
Well, let's say a broken leg. Any accident, ever, I'm not saying killed. Does that
or
matter?
hurt. Yeah.
Yeah, does that matter?
If there was a prior injury at that particular bus stop,
Well, I mean, you
not
seem to
in
be
terms
saying,
of whether it's safe or it was unsafe from the outset. They never had a program. It stayed unsafe, and all the criteria and all the standards said it's unsafe. And you had the people in the transportation department doing nothing about it. All they did was ADA, and that didn't make it safe, not by any stretch. Whether someone was injured or hurt there or not, it was unsafe. And this girl was hit right where Ashto said she would be. Right there. 2 driveways. 5.5 feet back without a curb. Thank you.
Counsel. We appreciate your argument. The time you've taken to prepare is apparent, and it's appreciated. We are going to take the matter under advisement at this time, and we will issue our decision in due course. Thank you.